Very good afternoon, everyone. This is Dr. Sanket Charkha from Sinhagad Institute's Savitribai Phule Pune University. We are starting with the subject of legal aspect of business, and in this concern, in the first chapter, we have dealt with Indian Contract Act. In the second chapter, we have dealt with Sale of Goods Act, and now third chapter, we are moving towards Negotiable Instrument Act of 1881. In the previous lecture or in my previous slides, we have understood or we have seen about what is the concept of Negotiable Instrument Act of 1881, what is RBI Act of 1934, and what is Indian Paper Currency Act of 1871. Further, we have seen what is the definition of negotiable instrument with respect to the definition provided under section 13(1), which is also called transferable document, which is printed or written, and what are the various rules with respect to transfer on delivery. The definition or the meaning with respect to what is meant by negotiable and what is meant by endorsement. We have also seen what are the various features of negotiable instrument, wherein the various features are called as it is freely transferable, defects in title, the remedy, rights, payable to order, payable to bearer, payment, consideration, and presumptions as to negotiable instrument. So what are the various presumptions as to negotiable instruments? Now let's look at the next slide. First concern, that is presumptions of negotiable instruments with respect to as to consideration. Everywhere at any now, as you have seen, that is we are having the concept of essential elements of a valid contract or essential elements of a contract of sale. In the same way, we have various presumptions or certain formalities or certain considerations in which a negotiable instrument must have. If those particular considerations are not available in terms of a negotiable instrument, the negotiable instrument cannot be treated as a legal or as a valid tender. So a particular instrument, in order to be legal, in order to be valid, the several presumptions must be fulfilled or it must be occupied. First presumption as to consideration. So here at every stage, every point of time, whenever passing or whenever we are preparing any negotiable instrument, it must have a certain value, and that particular value must be associated with a certain number. That is, if you are preparing a negotiable instrument, whether it is a promissory note, check, or a bill of exchange, always it must be having a value. Now that particular value must be in terms of specific currency itself. That is, if the negotiable instrument is prepared in India, then it must be it should be specifically in terms of rupees. If you are preparing in US, then it must be specifically in terms of dollar. If you are preparing in Europe, then accordingly in terms of euro currency and so on, respectively. Each country applies for each consideration and each value what has to be considered for. Now, these particular value, now whenever we say or are concerned with respect to consideration, all the essential elements of consideration as to the value, quantity, specifications applies at this particular stage. Now, whenever consideration is been considered, the value must be in a full and it must be specific. That is, we have to be very specific whenever we are mentioning the consideration, whenever we are mentioning the amount. That is 10,000, 20,000, 50,000, 1 lakh, 5 lakhs, 10 crore, and so on. So you cannot mention or you cannot we cannot draw a particular check stating that key pay Mr. Sanket Charkha, for example, 10,000 to 15,000. So in these way, we do not form a particular check. We specifically mention a particular amount. That is, the check must have an amount that is either 10,000 or either 15,000. Any one amount can be mentioned, and both that is two amounts cannot be mentioned. Consideration, the negotiable instrument can be drawn for a consideration which is either past, present, or future. So whichever type of your consideration may be, you can form or you can draft a particular consideration for either past, present, or future activities also. That particular activity, that particular amount must be very specific, and it can be considered for any type of contract or any type of law that is into existence. Presumption as to date. Always a negotiable instrument must have a certain date, and without a date, a negotiable instruments cannot be treated as a perfect legal valid tender. Now, this particular date must be of two types. The first type of the particular date in terms of negotiable instrument is when you are preparing the negotiable instrument, and on that particular date, you can prepare that particular negotiable instrument. So a particular negotiable becomes valid or becomes enforced only when a particular certain date has been imprinted or it has been written on it. So either you can print a date or you can write the date by your written handwriting. You are writing a particular check, you are writing a particular bill of exchange, or you are writing a promissory note as on today, that is on 5th of March 2021, then accordingly the presumptions of negotiable instrument with respect to date will be these specific date. Furthermore, always there is a certain concern of due date for that particular concern. That is, whenever you prepare a negotiable instrument, always it carries or it follows with a certain due date. Now, whenever you will be dealing with the types of negotiable instrument in terms of bill of exchange, it is always having a certain due date or a certain deadline, whichever the party has been mentioning for. You can mention it, for example, for 1 month, you can mention for 2 months, you can mention for 6 months, you can mention for 1 year, 2 years, and so on. If you are preparing a promissory note, the promissory note can be either for 1 day, for 5 days, for a month, for a 6 months, for 10 years, and so on. But in case of a check, not a major consideration with respect to RBI Act, that is of 1934, the Reserve Bank of India has given a certain consideration or various amendments has made into act stating which the particular check is valid only for 3 months. So if you are preparing or if you are drafting a particular check as on 5th of March, then it will be valid for only 3 months. That is April, May, and June. So on 4th of June, the particular negotiable instrument will lapse and accordingly you can get the payment. So presumptions as to negotiable instrument with respect to specific date. That is, whenever a particular negotiable instrument has been prepared, you have to see that a proper date is been inserted on the either check, promissory note, or bill of exchange. So if a particular negotiable instrument is not having a certain date, then it cannot be dated as a perfect legal valid tender and it stands cancelled or it stands voidable. As to time of acceptance, always it has been presumed that negotiable instrument will be accepted in the same form or in the same format. So whatever format is applicable for this particular concern, whether the negotiable instrument is prepared for a certain concern with respect to either a promissory note or a bill of exchange or a check, whatever you're drafting for, at every stage it must have a certain format, and that particular format or a particular acceptance must be accepted in the same format or in same fashion only. So as to time of acceptance specifically means that you have prepared a particular negotiable instrument as on today, but the date on the instrument is on 8th of March, then accordingly it must reach to a certain person or the respective intended party or before or on the date of 8th of March only. So accordingly we have to see on which date the negotiable instrument is accepted, and based on that particular specific date it has to be accepted within the specific time period, and then only it can be treated as a perfect legal valid instrument. Next thing, as to time of transfer. So if now here the Negotiable Instrument Act specifically gives a certain authority or a certain right to an instrument to be endorsed several number of times. That is, if you want to transfer a negotiable instrument to one party, two parties, five persons, 10 persons, or several number of persons or several number of parties, then accordingly it can be negotiated, it can be endorsed to several number of parties also, which is called as a transferable. Why? Because ultimately it is a feature, it is a basic essential need or a feature of a particular negotiable instrument with respect to characteristic that it is freely transferable from one person to another person. Now, how it is freely transferable? Just by signing on the face or on the back of that particular instrument, the negotiable instrument gets transferred. That is, the right of ownership, right of possession gets or transferred from one person to another person. So in this case, as to time of transfer, now within the specific time period, that is, you have prepared a negotiable instrument as on today, that is on 5th of March, and accordingly you are transferring the or you are endorsing the instrument after 6th of June. Now our deadline of the instrument or the validity of the instrument for 3 months, a particular check is valid for 3 months, that is April, May, and June. Accordingly, within the specific duration of 6th of June, you have to, that is 4th of June, you have to transfer or you have to endorse that particular instrument. If you sign or if you endorse that particular instrument on 6th of June, then that particular endorsement or that particular transfer will not be applicable. So we have to see as to time of transfer, that is when the instrument is transferring from one person to another person, what is the time, what is the deadline, what is the due date of transfer of that instrument. As to order of endorsement, so there is no limitation as to order of endorsement, and the endorsement, the negotiable instrument can be endorsed to several number of people, so several number of parties also. There is no limitations for the endorsement purpose. In terms of endorsement, the major consideration here or the major point that one has to look for or they have to remember is just signing the respective instrument. So whosoever is holding that particular instrument or on whose name the instrument has been drawn, only they have to sign either on the face or on the backside of that particular instrument, and it can be transferred to several number of people. As to stamp, so everyone must have heard a certain concept called as a stamp duty. Now, what is the concept of stamp duty? That is, for preparing any legal tender or preparing any legal document, we have to pay a certain sum of money or in form of a revenue to the government. Now, the government may be either state government or it may be central government. And whenever we prepare a legal tender or whenever we prepare a legal document, we purchase either revenue stamps or we purchase a court fee, or we pay either court fees, or we prepare or we purchase the stamp papers from respective advocates or the service providers in the different stores. Or whenever you go to the court premises, you can get a stamp paper. Now the stamp papers are also available of rupees 50, rupees 100, 200, 500, 1000, and so on. So a particular negotiable instrument, in order to be a perfectly legal tender, so that it is acceptable and it is having a validity in terms of the eyes of law, we have to see that a proper stamp duty is also being paid with respect to negotiable instrument that you are preparing. So in case of promissory note or a bill of exchange, always the stamp duty is paid by the respective the person who is preparing the negotiable instrument. But in case of the check, the person who is holding the particular instrument or the particular person who is owning that particular document, he has to pay the stamp duty to the respective government authorities. Now, in terms of negotiable instrument of either promissory note or bill of exchange, so if you are the promisor, or if you are the preparer of that particular instrument, that is, you have prepared that instrument, then accordingly you pay the stamp duty or you pay the necessary charges to either state government or the central government. But in case of your check, your the bank is not paying a certain sum of money, but you as a particular customer, you are paying a certain sum of money for preparing or for holding that particular checkbook. So if for example you have account in State Bank of India, and now whenever you apply for a check, so what is the concern? The bank will not provide you checkbook for free of cost, and the bank is charging you a certain sum of money. The first checkbook may always usually as a part of service, the bank is providing free of cost, that is up to 20 leaflet. But after this particular point of time, the bank is charging you around 2 rupees to 3 rupees per check. It depends on bank to bank. So here there is freedom, there is a concern with respect to the necessary stamp duty that respective each bank has to charge for. So for preparing a particular check, for printing that particular check, for ECS making of that particular check, for providing a particular security code, a particular check is being provided with a certain considerations, and that particular consideration is paid is paid in terms of stamp duty by the banking authority to the central government or the state government, whichever into existence. So if a bank is registered in a particular state authority, then the stamp duty is paid to the respective state. And if the bank is registered at the national level, or it is a public sector or private sector bank under the purview of RBI Act, then accordingly you have to pay the respective stamp duty to the central government as to holder in due course. So at every stage we can identify or we can understand about who is the person who is holding a particular document. Now in my earlier example, whenever there was a certain due or whenever there was a certain liability wherein Mr. Dada has to pay rupees 10,000 to Mr. Soham, and for paying this particular amount of money he has drawn a particular check. Now Dada is staying in Pune and Mr. Soham is staying in Amaravati. Then at this stage there is no connecting link, and how this particular instrument can be given to Mr. Soham. So at this stage what happened, Mr. Dada, what does he do? He handovers the check to Mr. Sanket, and that is Mr. Dada has prepared a check. The check was handed over to Mr. Sanket, and accordingly Sanket is going to deliver the check to Mr. Soham. So what is the chain? Earlier there were only two parties to this particular agreement. Now there are three parties available to this particular contract. So now the two parties, that is initial two parties, are Mr. Soham and Mr. Dada. Now the third party is Mr. Dada, Mr. Sanket, and Mr. Soham. So what happened? Mr. Dada has given the check to Mr. Sanket. Now Sanket is the holder in due course. So here holder in due course means the particular person or the particular party who is holding a negotiable instrument for a specific time period. That is until and unless the document has been delivered to that particular person. And once the document is delivered to that particular person, the person who is receiving that instrument becomes the holder of that particular instrument. So in this case, every stage we have to identify whether a person is a holder or whether the person is a holder in due course. There are various case studies or the various case laws with respect to holder in due course, wherein a particular negotiable instrument can be misinterpreted or it can be misused at every stage or point of time. So what are the, now in the further course of duration, you have various considerations with respect to what are the rights, duties and liabilities of person who is holder in due course. So there are different rights for the person who is preparing the instrument. There are different rights to the person who is holder in due course of that particular instrument, and there are different rights with respect to the person who is the real owner of that particular instrument. So in this way, we have to identify about who is a holder, who is a preparer, and who is the person who is holder in due course. As to proof of protest, now proof of protest is a particular concern wherein we have to identify about whatever the legal duty, whatever charges or whatever legal formalities are come into existence. We are making a certain consideration, we are making certain guidelines, and accordingly each and every concerns with respect to the government authority is being fulfilled over a period of time. So proof of protest specifically understands about a certain concern, that is if any legal formality or if any legal condition comes into existence, then whether we are making or whether we are complying all those formalities, norms and considerations, and accordingly whether all the formalities have been completed or not completed. So at every stage we have to see about the proof of protest is been undertaken or not undertaken, and accordingly the stamp duty, the legal formality, that is proper preparing of the document, proper signing of that particular document, it has been done or it has been not formality. And if a particular formality is not been fulfilled, then accordingly the respective commodity or the respective transaction cannot be held as a legal transaction or a legal commodity in terms of the eyes of law, and your transaction will stand cancelled. So there are various presumptions as to negotiable instrument, and for each and every negotiable instrument to be a perfect, legal and valid, we have to see about which considerations have been fulfilled and whether the formalities have been complied or they are not been complied. Consideration and presumptions, again I repeat, as to consideration, as to date, as to time of acceptance, as to transfer, as to order of endorsement, as to stamp duty, whether whatever you have to pay, as to holder in due course, and as to proof of protest. Now, what are the various negotiable instruments? So the basic classification or the major classification of negotiable instruments are under two categories. First thing, the negotiable instruments which are been recognized by statute and which have been used, and the second is which are being used for the custom or trade purpose. Recognized statute means which is having a legal tender, which is having a certain value in terms of eyes of law. That is, various provisions in the Negotiable Instrument Act and the RBI Act and the Paper Currency Act has been made, and accordingly it is having a legal tender or a legal value. So those different three types of instruments are bill of exchange, check, and promissory note. BOE stands for bill of exchange, C that is check, and PN stands for promissory note. Now, various instruments which are being used for the custom or trade purpose are first is the bank note, that is the proper paper currency note, wherein you have as on today a legal tender notes of rupees 1, rupees 2, rupees 5, rupees 10, rupees 20, rupees 50, rupees 100, rupees 200, rupees 500, and rupees 2000. So different banks notes wherein the Reserve Bank of India has provided a certain authority or a certain consent with respect to the legal tender or a legal purpose for exchanging the goods and services or a legal currency which can be circulated in the economy. SC stands for the share certificates. So various share certificates have been issued in the earlier scenario, that is before 2000 era. The share certificates was been provided physically, but now after the 2000 era, that is digitalization era or the IT Act has came into existence. Now all the share certificates are converted into a demat account, and accordingly everyone's share certificates gets dematerialized, and hence a particular person holding a demat account, their share gets transferred, or the entry of that particular share is been provided into demat account. Next is the share warrant, that is if you have purchased the shares in the bulk quantity, or if you have given a certain warrant or a certain undertaking with respect to your share certificate, then those particular documents or transactions are called as an share warrant or a share extension to the share certificates. Dividend warrant, so if a particular dividend is being payable for you, and based on those particular dividend, if a particular amount is being paid, then accordingly the dividend warrant is being issued, and accordingly the customer who is holding the amount of dividend, if a particular company has declared a certain dividend, then the customer will be holding the dividend warrant at this particular stage. Next thing is the deed. So various trust deed, partnership deeds, government deeds have been prepared, and based on those particular deeds we can identify or we can see about which document is been signed. If a particular partnership deed or a trust deed, excuse me, hello, huh? हो अरे 1921 चं ठीक आहे टाकतो एकच मिनिट. हां, आय नीड टू सर्च, आता कुठे शोधू. Hold on for 2 minutes. I need to send a placement mail. IB. हा त्यानं मला लेक्चर मध्ये उगाच डिस्टर्ब केलं ना. ते मुलाचा सीव्ही नंतर आला म्हणून मग नंतर टाकलं, आणि आधीच्या ह्याच्यात तो जुना सीव्ही होता बहुतेक. हो हो येस. अननेसेसरी डिस्टर्ब करतात. नाहीतर काय. Am I audible? Hello?
Yes, sir.
Yes, sir. Okay. Continue. You can see the screen.
Yes, sir.
Okay. So share warrant, now dividend warrant and deeds. So in terms of deeds, we were dealing with partnership deed, trust deeds, and so on. So if a particular deed is being prepared for between several parties or several companies, then accordingly it is used for the custom of trade or business purpose or business activities. And lastly, government promissory notes. Government PN or government promissory notes are those particular concerns wherein in order to exchange a certain goods or in order to exchange a certain commodity between the different government authorities, the government promissory note is been prepared and accordingly it has been signed. So for example, if Maharashtra government wants to purchase certain goods, services, commodity articles from New Delhi government or Madhya Pradesh government or Assam government or Tamil Nadu government, then accordingly they prepare government promissory notes and accordingly the exchange of money, commodity or services has been undertaken in terms of government promissory notes, and accordingly the instrument that is being used is for the trade purpose or for the business purpose. Now, in this case, at this particular stage, as per your syllabus, you have to study only the instruments with respect to which are being recognized by statute, but the instruments which are being provided for the customs of trade at this stage, they are not for your particular syllabus. So we are not going to study what are banknotes, what are share certificates, share warrant, dividend warrant, deeds, and government promissory notes. Only three major perspectives, that is certificates, the instruments which have been recognized by statute, that is bill of exchange, check, and promissory notes will be taken for your study. Now types, the various three types of negotiable instruments are bill of exchange, promissory note and check that we will be studying, and hundis are no longer into existence because after RBI Act in the year 1935, hundis are no longer into existence and hence the hundis is not available into your syllabus. Now what are the concept of hundis? Now whenever most of you must have visited Tirupati Balaji temple. Now at this stage, at that particular place, you must have seen a particular pot or particular cloth has been kept, and in that particular cloth is called as an hundi, and whosoever feels to deposit a certain sum of money or to give a certain donation, then accordingly we deposit a certain sum of money, and in that particular concern, the amount is been collected. So if you want to make a payment to a particular trust, in the earlier scenario or in the olden days, bill of exchange, promissory note and check was very rarely used, and people used to deposit a certain sum of money in that particular hundis. So different temples, different charity, different organizations, different organization, that is religious organizations used to collect a certain sum of money in terms of hundis, which was been kept outside a particular concern. Or you may simple say, you can understand as a dan peti. So if you don't want to get a certain receipt of this particular concern, then accordingly you can go deposit a certain sum of money in hundis, which is also called as a dan peti, and accordingly the amount that is a negotiable instrument can be given for them. But hundis are no longer into existence, and accordingly it is not having a legal value or legal tender as a major perspectives. Now, various essential elements of negotiable instruments. So with respect to negotiable instruments, what are the various essential elements? As we have seen, the essential elements of contract and essential elements of sale of goods are. First thing, always a negotiable instrument must be in form of writing. So unless and until a negotiable instrument is in a written format, it cannot be treated as a perfect legal valid tender, and it is not having a legal object or a legal validity. So we have to see about if a negotiable instrument is in writing, then only it can be treated as a legal tender. Otherwise, a oral instrument is of no use or it is of no importance. Next thing, parties, depending on the concern, depending on the transaction, there can be two parties or there can be three parties to a negotiable instrument, or there can be several number of parties to the negotiable instrument. The first party is the person who is preparing the instrument, and the second party on whose name the instrument has been prepared. That is, for example, a particular check. Now, a particular check is having three parties. That is, a particular check is being prepared by one person. The payment is made by a certain another person, that is the bank respectively, and the person who is receiving the check, that is the third person who is getting the payment or who is receiving the payment. So in this way, there are three parties to negotiable instrument. In case of a promissory note, always there are two parties: the particular person who is preparing the instrument and the second person who is receiving the promissory note. In case of bill of exchange, the bill of exchange is having either two parties or either three parties, depends on situation, depends on condition. For example, if a person is preparing a promise, that is bill of exchange, and it has been given to some another person and it gets negotiated immediately, then we can say that the negotiable instrument is having two parties. If the negotiable instrument gets transferred to काय आहे?
तेव्हा निघतच नाही वाटतं नॉन क्रिमिनल
मग
सर्टिफिकेट लागतेच
कसलं सर्टिफिकेट? So different parties to the are also available at this particular stage, and accordingly respective parties can make the payment accordingly. Now order to pay, always a negotiable instrument is a certain concern wherein it is always having an order to pay a certain sum of money to a certain person. So always it is having a specific order about who is making or who is preparing the instrument, and the payment is made to which party or which person is making the payment always. So here in case of negotiable instrument, it is an essential element, that is the parties to the negotiable instrument must be very specific about who has prepared that instrument and who is making a payment and to whom the payment has to be made. All these things has to be mentioned very specifically. Unconditional, always the negotiable instrument must be unconditional, and there must be no terms and conditions that have been associated with a particular negotiable instrument. So there it must not be having certain terms, certain conditions based on which the negotiable instrument can be either honored or it can be dishonored. So always it must be very clean, it must be very clear, and no conditions can be laid on framing or preparing of the negotiable instrument. Signed, always a negotiable instrument must be have a signature, proper signature or a signatory or by the person who has prepared and by the person who has accepted that negotiable instrument. So if a particular person is preparing and if the particular person, some another person is accepting, both the parties to the negotiable instrument must sign that specific document, whether it is promissory note, check or bill of exchange. And without a signature, negotiable instrument cannot be treated as a perfect, legal, valid tender. Persons directed drawing must be certain. So person directed in the sense that is all the parties to the negotiable instrument must be very specific and must be very concerned and specific. So if I am saying that okay, you want to make a payment to Mr. Sanket, then accordingly the specific name of Mr. Sanket in the specific spelling, in the specific format, and the specific words has to be written, and accordingly the drawing must be also certain. That is the person, now the drawer means the particular person who is preparing, and drawing means the particular person who is receiving the payment. So in this case, the drawer and drawee at this stage must be very specific and must be same. Money, which means specifically the consideration that is available at this particular stage. So always it must have a specific amount or a certain value. That is, if you are preparing a negotiable instrument for rupees 10,000, then accordingly 10 and 000, the specific amount must be mentioned. If you are preparing a negotiable instrument for rupees 10 lakhs or 10 crore, then accordingly similar number of zeros must, or a similar number of alphabets or digits can be added accordingly. And another concern, that is if you are preparing a negotiable instrument, if you are mentioning a certain sum of money, then the amount in words and amount in figures must also be same and it must not be different. Payee must be certain. So if there is a third party that has been associated to a negotiable instrument, then the payee must also be very certain and the payee cannot change. That is a particular check that has been prepared by you. Now you have a respective account with State Bank of India, and accordingly what you are doing, you are telling Axis Bank to make a certain payment, then accordingly Axis Bank cannot make you a payment. Why? Because your account is with the State Bank of India and you have to deposit the check in State Bank of India, then another third party bank cannot make a certain payment on those particular behalf. So in this case, the payee must also be very certain and it cannot be changed from situation to situation, concern to concern, and so on. Certain sum. So always a certain value must be associated with a negotiable instrument, and a proper transaction correlation must also be shown. So if a negotiable instrument is being used for a certain business purpose, then accordingly for what purpose you have prepared those instruments and why you are using. If you have mentioned a certain purpose or if you have mentioned a certain reason, then accordingly what quantity, what quality, what type of goods has been purchased and what amount has been decided, everything must be very specifically mentioned, and then only the certain sum or a certain value must be mentioned. The certain sum, whenever you are mentioning, the amount in figures and amount in words must also match, and accordingly it must have a certain specific value which is always very calculable and measurable. And lastly, as to stamping. So whenever we were dealing with the presumptions of negotiable instrument, there was a major concern as to stamping. So here every party to the contract, that is the party, whether it is a drawer or whether it is a drawee or whether it is a payee, the respective stamp duty with respect to the preparation of the negotiable instrument must be clarified, and accordingly the party to the contract must pay a respective stamp duty. So whether the stamp duty is 1 rupee or it is 5 rupee or rupees 40,000 or 50,000 or 1 lakh or 10 lakh, accordingly the stamp duty either to the state government or central government must be paid by the respective parties who are parties to the negotiable instrument. Now let's look at the first perspective, that is promissory note. According to section 4 of the Negotiable Instrument Act of 1881, now what is the definition? A promissory note is defined as an instrument in writing containing an unconditional promise or an undertaking signed by the maker to pay certain sum of money only to the order or to the bearer of the instrument. So here two parties are made available. That is, the person who is preparing the instrument is called as a maker, and the person who is receiving the instrument is called as an payee. So who is getting the payment is called as an payee. Definition: a promissory note is defined as an instrument in writing. So always instrument in writing is into existence, and whenever we say it is in writing, it must be in a printed format and must come on a paper. So unless until a negotiable instrument is on a paper, we cannot treat it as a negotiable instrument for that particular document. Containing an unconditional promise. So always a negotiable instrument is unconditional. So here the features of negotiable instrument is been fulfilled, it has been identified, and it has been conducted. So unconditional promise or an undertaking. So it is just an promise. So now what is the concern of promise? You may fulfill a particular promise or you may not fulfill a particular promise. So in this case, a promissory note is a particular concern wherein you may either perform or you may not perform. So here in this case, the promissory note is not binding on the respective parties, which is always signed by the maker. So here again a presumption with respect to signature. So always a proper signature must be identified, the document must be signed very carefully. To pay a certain sum of money. So always the amount must also be very certain. That is, if you have prepared a promissory note for rupees 10,000, then accordingly 10,000, the amount must be mentioned very specifically. And in case of words also, TENTHOUSAND, the full words must be written very carefully. To the order or to the bearer. So whosoever is bearing that particular instrument. So if the negotiable instrument or a promissory note is of a bearer nature, then the person who is holding or bearing that particular instrument can get a certain amount, or the particular person to whom it has been specifically ordered, the person whose name is been mentioned in that particular instrument can get the payment of that particular amount. Specimen of promissory note. So here the amount that has been specifically mentioned, that is rupees 10,000, Delhi, May 10, 2020. 3 months after date, I promise to pay Rajiv Khandelwal or order the sum of rupees 1,000 only for the value received. So here presumption as to time. So here when I have prepared this instrument, the instrument is prepared on 10th of May, that is 2020. And what is the validity? The validity of this particular instrument comes due after 3 months. So that is 10th May, June, July, and August. So until and unless 10th of August is been arrived, that is 3 months after this particular date, the promissory note cannot be executed and you cannot get the payment of this particular concern. 2. Now, who is the particular person to who it has been addressed? It has been addressed to Mr. Rajiv Khandelwal, and the particular person who is preparing is Mr. Ram. So here the stamp duty is been paid by the particular person who is maker of this particular instrument. So the maker of the promissory note is Mr. Ram, and accordingly he has to pay the stamp duty. And who is going to receive the payment? The promise to pay, that is Mr. Rajiv Khandelwal, get the payment. He is located in Mumbai, and Mr. Ram is preparing this particular promissory note in Delhi. So in this case, all the instruments or all the consideration or the presumption to a negotiable instrument have been fulfilled, and accordingly the negotiable instrument is drafted or it has been prepared. Parties to the promissory note: maker, payee, and holder. So maker, here in this case, maker of the negotiable instrument is Mr. Ram. Payee is Mr. Rajiv Khandelwal, and accordingly holder. So if any holder is there at this particular stage, that is this particular promissory note has been handed over to some person, and accordingly he is just holding that instrument for a certain specific time period until and unless Mr. Rajiv Khandelwal receive that particular instrument. That particular person who is holding that particular instrument will be called as an either holder or holder in due course. So the particular person may be called as an holder, or the particular person may be called as an holder in due course. What are the different types of promissory note? So different types of promissory note are the promissory note which is payable on demand, promissible payable after the date, joint promissory note, and joint and several promissory notes. So payable on demand. So here 3 months after the date, I promise to pay sum of rupees for value received. So this particular promissory note which is of a simple nature can be called as a promissory note which is payable on demand. Payable after the date. Now here in this case, what you can do, here we have specifically mentioned that is after the date. That is, if the particular date, unless and until the particular specifically date arises, that is 3 months after the specific date, that is June, July, and August. So payment will be after 10th of August. Now here you can remove this particular concern also. That is, if this particular word is removed, 3 months, I promise to pay. So now here 3 months within the date also can be specifically written. Within the date. Now here what I am doing, I am specifically mentioned that 3 months within the date. So what is the date as on today? That is the date as on today is 10th of May, and within this particular, that is with the 3 months within this particular specific date, that the particular person, that is if Mr. Rajiv wants to receive a certain amount of payment, then he has to produce, he has to get this particular document encashed to his respective banker, and accordingly before 10th of August he has to produce this particular document, and accordingly the payment can be received. If he produces this particular document after the 10th of August, then accordingly he will not get the payment and he will not be entitled to receive any sum of money. Joint promissory note, a particular promissory note be prepared for 2 or more parties. So pay Mr. Rajiv Khandelwal and Mr. Sanket Charkha. So here what am I doing? I am inserting 2 parties at this particular stage, and accordingly 2 parties can also get the payment at this particular stage. So here there can be joint or several promissory notes also, promissory note at this particular concern. Joint and several promissory note, I can prepare a promissory note for one transaction separately, for a different transaction separately, and the party may be same. That is, for Mr. Rajiv Khandelwal, you can prepare the promissory note for rupees 1,000, for rupees 5,000, for rupees 10,000, for rupees 20,000, for rupees 50,000, 1 lakh, and so on. So in this way, we can see that a single promissory note can also be prepared, a joint promissory note can be also prepared, and several promissory notes can also be prepared at every stage or point of time. Moving in the second perspective, that is bill of exchange. So according to Negotiable Instrument Act 1881, a bill of exchange is defined as, and so what is the definition of bill of exchange? An instrument in writing containing an unconditional order signed by the maker directing by a certain person to pay a certain sum of money, or to the bearer, or to the order of the particular instrument. Now just identify or just look for the slight difference between promissory note and the difference between bill of exchange. In case of promissory note, a promissory note is always a promise or an undertaking, whereas a bill of exchange is specifically an order. So only one word is differentiating at this particular stage, and here the major concern or the major word that can be identified is the order. In terms of promissory note, whether you perform or whether you not perform, it is not binding on the parties to the contract to perform their promises respectively, and whether to honor the instrument or whether not to honor the instrument. So it is a certain promise, that is, if you feel you can have a promise, or that is you can make a payment, and if you do not feel, you cannot make the payment to the interest party. But in case of bill of exchange, it is a specific order. So here you have what you can see, an instrument in writing containing an unconditional order, and whenever a particular order is been given by any person, it has to be followed mandatory, and it has to be followed in anyhow condition. So here we have to see, or we have to identify what is the difference between a promissory note and what is the difference between a bill of exchange, and whether it is a promise or whether it is an order. So if it is an order, it becomes bill of exchange, and if it is a promise, it becomes promissory note. Rest all the things remains the same, that is, it is signed by the maker directing by a certain person to pay certain sum of money only to, or to the bearer, or to the order of that particular instrument. Now here look at the particular concern or the format of bill of exchange. So here again a stamp duty, the place, the date, rupees amount in words and figures is also same. Now only the difference at this particular stage is on demand. So unless and until the particular party demands for these terms of payment, the bill of exchange does not becomes valid for making a certain sum of money for a payment concern. So the party who is receiving a certain bill of exchange must demand, and accordingly he must produce the particular negotiable instrument. And if he do not produce the instrument for payment purpose, then he will not get the payment as and when it is been required. So who is the receiver of this particular concern? Mr. J, who is of Mulund, he is the receiver of this particular instrument, and Mr. Jimit from Mumbai, he has prepared those particular documents. So Mr. J, he has to go to the respective bank, and accordingly he has to produce this particular negotiable instrument for the payment purpose. So unless and until Mr. J produces this particular document, it will not be encashed, the payment will not be received, and accordingly on demand of the particular person only the payment can be given. Now, what are the various parties to bill of exchange? So various parties, again, 3 parties: drawer, drawee, and payee. So drawer is a particular person who is preparing the instrument, drawee is a particular person who is receiving the instrument, and payee is a particular person who is making the payment on behalf of the drawer. So this particular bill of exchange that you have prepared, it can be encashed to the bank also. That is, if you feel that the payment has to be paid by the respective bank, that is, you get it encashed or you get it endorsed with respect to the specified banker, that is, you have account with Axis Bank or ICICI Bank or State Bank of India or Punjab National Bank, then you can go to the respective banker, and accordingly the respective specific bank can also make you the payment. So here the payee becomes the bank. Now different types of bill of exchange. So different types of bill of exchange are demand bill, time bill, inland bill, foreign bill, trade bill, and accommodation bill. Demand bill, it is specifically concerned, that is a normal terms and conditions, that is on demand pay Mr. J of rupees so and so. So here the example is of demand bill. Time bill, so here on demand within the due date, that is on demand within 3 months. So within 3 months, I can specifically mention for a specific time period. So here it becomes a time bill. So here I can see that is today is the 5th of March, and accordingly within 3 months, that is April, May, and June. So within 3 months, that is within before 3rd of June, the instruments has to be produced to the payment to the respective banker, and accordingly the payment can be received by the interested parties to the contract accordingly. Next comes a certain picture with respect to the inland bill. So inland bill, a particular bill which is payable, which has been acceptable, or the bill can be encashed within or regional boundaries of a particular specific country only. So that particular bill will be called as an inland bill. So if a particular bill that has been specifically drawn and it has been specifically mentioned for the inland purpose of India only, then accordingly the bill of exchange will be paid in terms of Indian currency or in terms of Indian regional boundaries only. Foreign bill, a particular bill can be which can be paid outside India, or it can be specifically paid outside India only and not within India, and it can be identified in a specific currency also. So if you feel that you want to prepare a certain foreign bill or foreign bill of exchange in terms of dollar, euro, yen, pound, or any type of currency, then accordingly you can prepare a bill of exchange in terms of Western or the foreign currencies also. Trade bill. Trade bill is a particular bill which has been specifically used for the purpose of trade or for purpose of business only. So for the regular routine purpose, for a regular retail purpose, this particular trade bill cannot be accommodated, it cannot be used, and accordingly you have to use the type of trade bill for business payment purpose only, and it can be deposited in your business account only and not in the savings accounts also. So only current account, the business account can be used, and the bill of exchange can be getting encashed in those particular accounts only. Accommodation bill for a certain purpose of the or which is being used for a certain specific purpose or for a certain motive. The bill of exchange which is used for a specific concern of a certain nature, that particular type of bill is called as an accommodation bill. Accommodation bill can be accommodated for a several number of parties. That is, if you want several parties can be accommodated, if you want several locations to be included, several features to be amended, then accordingly the bill of exchange which is used for a different purposes is called as a accommodation bill or a trade bill. So different types of bill of exchange, that is demand bill, time bill, inland bill, foreign bill, trade bill, and accommodation bill are into existence. Check. So now what is the definition of check which has been provided in Reserve Bank of India Act of 1934? A check is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise on demand. So here at this stage, what is our concern? Now a check is an extension to the bill of exchange. So whatever concern we have seen in terms of bill of exchange, it is an additional or it is an extension to this particular concern. But here it is having a specified banker. So always check is been associated with a certain specified banker, and it must also have a certain banker with respect to making the terms and conditions of a certain payment perspective. So unless until there is no specified banker for a particular check, the check cannot be treated as a perfect legal valid, and it must be expressed and it must be payable to other person who is available on demand. So unless and until a particular party demands come forward and make a purpose for making a demand for a certain payment per concern, the check cannot be made and the payment for the check cannot be identified or cannot be received. Specimen of a check. So here in this case, pay dash dash or bearer the sum of rupees dash dash ICICI Ghatkopar East branch. So here in this case we can see, or you must have, everyone of you must have seen how a check looks like. So in this case we can see about what is the format of a particular check or what is the specimen of a check. I'll be sharing this presentation with you, so you need not to write or you need not to note anything. Major consideration, we have seen what are the various presumptions as to negotiable instrument of a check perspectives. So here no additional explanation is been required. The date must be there, the payee must be very certain, that is it must have a certain name, bearer or the sum of rupees. So here whenever we say sum of rupees, that is the amount you are mentioning in figures and the amount that you are mentioning in words, it must also be same. It must have a specified banker, and the specified banker must have a certain branch which has been associated. That is, you must be able to identify which accommodation or which location does it relate to. Signature, the particular person must sign that particular document very carefully, and accordingly the signature must match with the signature available with the banking perspectives. And lastly, it must have a certain concern with respect to check number. So always there must be a number to a particular check, and if a particular check is not having any number, then we can say that the check cannot be identified and is not a legal tender of check that has been into existence. So always the check must be having a legal tender, and accordingly it must have a certain number also which has been associated over a period of time. Parties to the check. So the person who is preparing a check is called as a maker. The on whose name it has been prepared, it is called as a drawee. The person who is making the payment is called as a payee. The particular person who is holding the instrument is called as an holder or holder in due course. If the particular instrument is being endorsed to a certain person, then the person on whose name the particular earlier check was being prepared is called as an endorser, and the particular person who is receiving the instrument is called as an endorsee. So 1, 2, 3, 4, 5, 6. So there are 6 parties to a check, and accordingly the parties differs from different types of instruments. So in case of a promissory note, there were only 2 parties. In case of a bill of exchange, there were 3 parties, and in case of a check, there can be either 3 or more parties, or there can be a maximum number of 6 parties to a check. Now, what are the various different type of check? Open check, a particular check which is of a open nature, wherein there is no written anything and only a particular check is being signed, then that particular type of check is called as an open check. Cross check, a particular check which has been written and it has been crossed by drawing put 2 parallel lines at the corner of on the left corner of that particular check is called as a cross check. Bearer check, wherein a particular check on which cross lines are not prepared and the holder of the particular check gets a certain amount of payment, and that particular type of check is called as a bearer check. Order check is a particular concern wherein you have a certain specific order based on which the payment to the interested party or payment to the certain specific amount is been specifically mentioned. Stale check, a particular check which has been lost or which has been misplaced by a certain person is called as a stale check. Post-dated check, a particular check which is being prepared after a certain due date is called as a post-dated check. Now, if I prepare a particular check as on today, that is 5th of March 2021, then the check can be called as an open check or a regular check. If I post a particular date on the, if I post a particular check on a particular date, that is 10th of March or 10th of February, or a particular date that is 10th of April 2021, then it becomes post-dated check. Account pay check, that is your particular check which is being payable in terms of the specific account of that particular payee only. Non-negotiable, a particular check which cannot be negotiated, which cannot be transferred from one person to another person, and such type of check is called as a non-negotiable check. Crossed more than once, so a particular check can be crossed several number of times also. So initially you can cross a particular check for a specific concern or a specific reason for depositing a check in terms of account, specific account, or you can cross a particular check for making the payment in terms of several terms and conditions also. So a particular check can be crossed several number of times also. Now, differentiation between bill of exchange, promissory note, and check. Parties in terms of bill of exchange, 3 parties. In terms of promissory note, 2 parties. And in case of check, there are 3 parties or 6 parties also. Drawee, in case of bill of exchange, drawee can be any person. In case of promissory note, the maker is the drawee. And in case of check, the specified banker, that is the person who is making the payment, that is the bank which is making the payment becomes the drawee at this particular stage. Payable to the creditor or the bearer, that is the person who is the creditor or the beneficiary of the document. In that concern, the bill of exchange is made, the payment is made to the specified person. In case of promissory note, the person who is either holding the instrument, or if a particular specific order is been given, then only the payment is given to the specific person in case of promissory note. And in case of payable to the check, the check is payable to a particular person who is either holding, that is the particular person who is bearing the instrument, or on whose name the instrument or a particular order is been specifically mentioned. Okay. That's all for today's lecture. We conclude here. Thank you everyone for joining this particular session.